All right, so I'm going to take this one. This one is something that I think I get a lot from people. So what is and the individual's name is John. So what's your best advice? I'm going into mediation, and I know that my ex will not agree on anything. Okay, so when it comes to mediation, it takes two to tango. There's no way to come to any sort of agreement if both parties aren't there to come to any sort of agreement. And this is kind of where it goes two different ways. So some states and some counties, actually, in California, mediation is what's called CCRC, Child Custody Recommending Counseling. And so that mediation, that mediator, that social worker who's doing that is going to, in turn, based on the mediation, turn around and write a recommendation. Now, that's not necessarily the most common setup, but if your state and your process does that, then you need to be aware of this individual is going to be making a recommendation. But the first thing I advise everyone to do going into mediation is you're going to find your non-negotiables. What do you absolutely have to get? What do you absolutely need in this mediation for you to be able to say yes? Because the worst thing you can do is you end up getting stuck up on something that doesn't really matter to you, and then the judge starts making decisions. So if your three things are you want 50-50 custody, you want joint medical, whatever it may be, you go in there and you understand that, hey, if I get these things, this is what I actually wanted. And I'm not gonna fight or fret over things that really don't matter to me, because those things may be on her list of things she absolutely needs. If there's gonna be a recommendation come out of it, there's gonna be a report come out of it. I always tell guys that to start every sentence, you say it's in the best interest of our child for X, Y, and Z to happen because of A, B, and C. So I tell my clients, you can't say it's in the best interest of our child too much. And that, number one, is it verbalizes you being child centric, and number two is it can help you as a parent in that mediation maybe stop being as petty and keep you focused on your child. Because that's going to be the biggest thing. If there's going to be a recommendation based off of those conversations and what happens, you're going to want to impress upon that individual that you are focused solely on your child. So it's not about attacking the other party. It's not about pointing out their flaws. It's about staying about your children and about what is best for them. If it's a situation where they're not making a recommendation, whether it be court-ordered mandatory mediation or whether it be private mediation, there are impasses. It happens in all negotiations. So in that sense, I usually would want to try to agree on as much as possible, take as much out of the judge's hands as possible, and then allow the judge to simply rule on those issues where there are those impasses. That a lot of times is going to be more cost effective. If you go to the judge and you have 15 issues and you're dealing with all the tiny little issues, that's going to be more time, more money to navigate through that. Where maybe you come to them and it's two issues. You're arguing over a couple of days, a month of custody, and then what the child support calculation. That's going to be a much more streamlined process. So that's kind of my take. I think mediation can be a phenomenal tool, but it takes both parties.